Hello, and welcome to Money Mystery No More. Have you ever wondered what happens with all your bills and debt when you die? That intrigued me recently, walking our dog. No surprise if you've never broached the topic. Death is not a warm, fuzzy, comfortable topic. It causes annoyance, anxiety, dread, and somberness. So most folks steer clear of it. But avoidance is not the answer. Estate planning, done right, can cause peace of mind for you, your family, and your intended outcomes. So here we are. Let's talk about estate planning and debt. To really get benefit and get the most out of this video, embrace the information and be prepared for some changes involving your estate planning and debt by keeping it simple. It's awesome. And remember, hit that subscribe button to keep getting the latest and greatest information. Okay, let's remove the mystery. You might have seen my prior episode, Essential Estate Planning Provides Peace of Mind, which was a fairly broad review of estate planning and its importance. We said whether you have $10 or $10 million, you have assets, which in turn means you have an estate. Your estate is the total of all your possessions and assets that you value, even if others don't see value. That can be your photos, jewelry, family heirlooms, a chair, a car, or some boots. Those assets are yours, a part of your estate. When you die, those assets need to go somewhere. That is what estate planning is all about. You get the ultimate say on who gets your assets, what happens with your assets, what happens to you if your health or mental capabilities go bad, and how all those things happen legally. Estate planning is about honoring your wishes. Your assets and affairs will be handled and distributed the way you want if you can no longer handle them or if you die. Morbid as it is, dying is serious business with many layers and details to handle. It's ideally done before you die so it's less confusing, frustrating, and stressful for those grieving and left behind. Our other video provides guidance about starting with the walkthrough to record a complete list of everything, literally everything you own, which will be considered your estate's assets. With that list, planning begins by documenting what you want to happen with those assets, along with your future personal well-being. Then you think of current and future as related to asset transfer, medical needs, and financial decisions. Asset transfer was covered in great detail during the other video, so we're going to glaze through it here. Remember, asset transfer is basically you legally directing your assets to specific entities or people in a lawfully binding manner. Done properly, your legally binding intentions are handled through a will, living wills, or trust as directed by a POA, lawyer, or even a law firm. Revisit that video to help start getting your house in order. If your health were to fail and you lose your self-sufficiency, your own medical needs must be known and planned for. You'll want to have someone appointed to make serious healthcare decisions on your behalf. Without an appointee, you may become a ward of the state, and some random person would decide your fate, maybe against your fundamental beliefs. This subject does need more vetting and discussion to offer guidance through proper estate planning. Financial decisions, that's the elephant in the room. This subject is broad, on a whole new level of planning. We're talking about covering everything related to your money, savings, investments, life insurance, loans on mortgages or vehicles, education expenses, credit card debt, all expenses, even medical debt. Yes, your estate planning can dictate what happens with your money coming in or going out. You see, your estate planning is your legacy if you desire. It provides the path for the authorities and those bound to legally handle your wishes the way you planned. There is some comfort knowing there's an option for your legacy to live on the way you intended and want. As stated, expenses are included, all of your bills and debts, including medical debt. After you die, someone is responsible to pay all that debt and open balances. Common sense might lead you to believe that your debt dies with you. You'd be right in most cases. Paying off a deceased person's debt is not an obligation legally required by any other person except for the deceased person, in most cases. Notice the "in most cases" clause. Various state laws with medical debt are involved. Death does not mean medical debt dies with you. Your estate is the first place debt collectors will look for recouping their monies. In fact, the main method of paying debt collectors is through your estate bank accounts or by selling your estate assets to generate that money. Where you live is also particularly important. Unless the estate can cover it, state law may require your children or your spouse to pay part of your healthcare costs. If residing in a community property state, your spouse may be personally responsible for your debts, including medical debts. Community property states consider assets and debts of one married spouse to be that of both spouses because it is the marital community property that both of you own or owe. When the estate can't cover the expenses, your spouse may be required to. Seriously, if you live in one of the 13 current community property states, your estate planning should factor an offset of that potential medical debt going to your loved ones. Your estate plan might use life insurance to pay directly or as a gift to those responsible for paying it, or offering some tax advantage means to assist them. Community property estates or not, there are instances when an estate does not have enough funds or assets to pay off all the debts. That estate may be deemed an insolvent estate because it's materially insufficient and unable to cover all the debts. In such a case, the debts are dropped, forgiven, or written off, whatever term you like. This would include medical debt. Outside an insolvent estate, creditors will seek payment for what you owe through the probate process, which is legally how your estate's assets and debts are paid. Creditors will submit their claims through probate. Standard procedure has your estate pay debts, but more exceptions may hold your loved ones responsible. One debt involves property and a mortgage. If the home title is in both couples' names, the house is jointly owned even if the mortgage is only in one person's name. In the event of death, the house and the debt goes to the surviving spouse. Estate planning commonly deals with this by securing a life insurance policy big enough to cover it. When nobody else is on title, the mortgage lies with the lender. Someone may get the property as a gift or be offered a right of first refusal, but nobody will get the property without the loan being assumed or paid off. Estate planning would proactively take care of this. It gets paid off, sold, or ultimately the bank would likely foreclose the property to recover their balance still owed. Another debt to be aware of is educational debt. You cannot escape your private student loan if you die. That loan, if in your name only, is usually paid with assets from the estate. Additionally, if someone co-signed for that loan, the lender will hold that person responsible for the balance. So, estate planning should factor these debts and a way to pay them off. Smile. Your federal student loans will be discharged and nobody will be responsible for the remaining debt. Federal student loan debt does die with the debtor or borrower. Then we have the infamous credit card debt. You might have already guessed. Any card with the joint account owner would result in that co-owner being responsible to pay any open balance. An authorized user, however, will not be held responsible for your credit card debt because they are not considered a co-owner. They're just someone you've given permission to use your credit card, not to pay it off. Sure, the credit card company would likely file a claim to get paid through your estate, but that's it. Co-owners would also be responsible for any debt owed on a vehicle loan. Again, this could be squared away with sufficient funds in a life insurance policy. Alternatively, the vehicle could be repossessed by the lender, it could be sold to pay off the loan, or someone might choose to keep the car and make the payments. Clearly, estate planning and debt are bigger than you may have initially realized. Get a person set up to legally handle your affairs responsibly and pay your bills with the state assets. They should be steadfast, with integrity, as they must adhere to state and federal laws or could be legally liable in the future. Conversely, if you fail to get a person set up, realize that the courts will, by appointing a guardian or an administrator to handle your affairs. Advanced estate planning will make the process easier for everyone. And if not already mentioned, it seems sensible to include life insurance into your estate planning. A payout could allow a number of debts to be cleared while relieving your intended recipients of a financial mess. Plus, life insurance is paid to a beneficiary upon your death, not to your estate, so a creditor likely cannot seize your life insurance. Creditors may resolve your debt with your loved ones though. A lower balance, a payment plan, an amended or renegotiated contract, debt relief, or waiving portions of the cost. Debt collectors are bound to the Fair Debt Collections Practices Act and must adhere to those rules. They may contact family members or your representatives, but have time restrictions and must stop contacting them if requested in writing. Debts must still be handled, but an attorney could be the main point of contact. If a debt collector wrongly goes after your spouse, kids, or family members for payment, or perhaps falsely dings their credit report, they need to learn their rights. They can fight it out and even file a complaint with the FTC, but some proper estate planning sure could take that sting away. Seeking professional help or estate law counsel may be wise and necessary. Your personal situation might result in an estate that's little or quite large. You can seek a wide range of services and legal input to help figure it out. Fly solo, use an online service, or get expert legal help and spend a couple hundred or many thousands. Whatever path you take, when it's done right, estate planning and debt are possible while providing peace of mind by keeping it simple. Remember, hit that subscribe button and turn on notifications so you keep getting the latest and greatest information from Money Mystery No More. I'll see you in the next video.